The Equal Rights Amendment was originally proposed in 1923. It was 100 years ago last week. There was a march in Washington, D.C. It was December 10th, 1923, when it was first introduced in Congress. And it's literally 24 words. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That's it. That's all it is. And those are the most controversial 24 words I think we could have ever put together. In order to have a constitutional amendment, the proposal has to be approved by 2/3 of both chambers of the United States Congress. And then it has to go to the states and be ratified by 3/4 of the states. So that's 38 states at this point in time. So it took the Equal Rights Amendment almost 50 years to finally be passed in Congress. It was passed overwhelmingly with bipartisan support in 1972. And then it went out to the states for ratification. And that was, a time where women's rights were really at the forefront. At that point in time, women couldn't hold credit cards. Title IX was just coming into effect, also in 72. So when it went out to the states, it was quickly ratified by 30 of the necessary 38 states within the first year. But that's when Roe versus Wade came in. And I don't know if you've ever heard of a woman by the name of Phyllis Schlafly, and she had a docuseries about Miss America, and she essentially led the anti-ERA movement. And it was one based on the same fear-mongering we're hearing today. Family values. We need to preserve the family unit. We can't have women drafted. We can't have gender-neutral bathrooms. All of the things you're hearing today are the modern day equivalent to what she was saying back then. But after Roe versus Wade, she was pretty successful in motivating people. And as a result, they only got to 35 states before 1979. And why do I mention 1979? The lead into the Equal Rights Amendment stated that the Equal Rights Amendment would be sent to the states for ratification within 7 years. But this was in the proposing clause of the Equal Rights Amendment. It was not in the text that was sent to the states. And that's fairly important because as a result of that, hundreds of constitutional scholars have said that the ERA is currently the 28th Amendment today. So after 1979, it was extended 4 more years to 1982, but there were still no more ratifications. And then it kind of fizzled. And then you fast forward to 2011, and Justice Scalia made some pretty shocking announcements that people paid attention to. He actually stated that there is nothing in the Constitution that prohibits discrimination based on sex. There's nothing that requires it, but there's certainly nothing in there that prohibits it. So women at that point in time got motivated, and they started what was referred to as the 3-state strategy. They were going to come up with the last 35 states needed to ratify the last 3 states needed to ratify the Equal Rights Amendment. So the first step they went to the United States archivist, and that is the librarian who's tasked with record keeping, which we've all heard as a result of who's holding records, presidential records and such. So it's the same person. It's a librarian, effectively. And the librarian at the time said that he would accept additional ratifications despite the 7-year reference in the proposing clause to the Equal Rights Amendment. So these activists went out and they got the state of Nevada to ratify in 2017. And then in 2018, the state of Illinois ratified. And each time the archivist accepted the ratification and certified it. So after Illinois, we were at 37. So what happened was
Nicole, I think you're frozen. I don't think it's me because I see other people moving on the screen. I see Jana's
Virginia
moving.
finally ratified on December 7th, 2020. How about now?
Okay. It was working, but you're still a little frozen. Okay,
Now,
so I can hear you.
can you hear me?
Yes, we can hear you. You're frozen on my screen, but I can hear you.
So
We need that broadband bill to pass.
Hey, it was been me all week, so I feel.
Well,
And
while we're, is she back yet?
I don't know if you can hear me, Nicole. Maybe we should leave and come back and see if yeah, I guess that's what happened. So, okay. Talks amongst yourself. We'll come back in a second. Hopefully we'll get her back here.
It was getting good.
Just going to offer up a fun fact while we were waiting. The
Okay.
27th
Can you
Amendment.
hear me?
Yes.
Yes. Okay.
Huh?
I am so sorry.
Hey.
What I think actually just happened was that my children came home and turned everything on. So yes, we need better internet for sure.
That would do it.
Okay. Hold on.
My
I'm gonna
apologies. My
Whatever.
apologies. Thank you, Alice, for chiming in and dealing with that.
Well, let me just tell you, you kind of left off. You were saying Scalia said shocking stuff about sex not being protected, and then you kind of froze. So that's where you were, and we were all getting into it. So
Okay. So yes, Scalia, set off a firestorm. And with the Me Too movement starting around 2017, women became supercharged. And Nevada ratified in 2017, and the archivist accepted the ratifications and the ratification and certified it. In 2018, Illinois ratified. And again, the archivist accepted the ratification and certified it. Fast forward to December 27th of 2020, when Virginia became the 38th and final state needed to ratify the Equal Rights Amendment. The archivist did not accept the ratification, did not publish the Equal Rights Amendment, and to this day, it's not in the Constitution, despite the fact that he had a statutory duty to do so. There's a provision that requires him to literally collect, look and make sure it's okay, and accept and then publish once it meets the statutory threshold, which is 38 states. Why did this happen? Because in December of 2019, right before Virginia ratified, it was imminent that it was going to happen. The states of Alabama, South Dakota, and Louisiana stepped in and initiated a lawsuit against the archivist, stating that the ERA was no longer valid because of the 7-year time limit contained in the proposing clause, as well as the fact that 5 states had purportedly rescinded their ratifications. At that point in time, a few weeks later, the Trump administration, which had no role in the Constitution amendment process whatsoever, intervened, and its Department of Justice Office of Legal Counsel issued a memorandum that said the ERA has expired. You must start anew. You did not get enough ratifications within the 7 years, and start again, ladies. Well, that was pretty significant, because what it in fact did was it took the burden of proof to prove that the ERA was invalid and shifted it to the people who favored equality and required them to prove that the ERA was in fact valid. There have been 5 lawsuits since then, where 2 of which where the parties tried to compel the archivist to publish the Equal Rights Amendment. And the other one was, and there were 3 more recently, where the plaintiff, the Elizabeth Cady Stanton Trust, was attempting to establish that the ERA was already valid. And she did that, the trust did that in 3 different states. In each instance, proponents of equality have been unable to overcome these substantial burdens, procedural burdens of standing, or in order to compel a government employee to act, it has to be clearly indisputable that they have a duty to act. And courts have ruled that we can't meet that burden because of the language in the proposing clause. To this day, no one has ruled on whether or not the ERA is valid. And that's some of the misinformation you find out there right now, because people will say, oh, it expired, you have to start all over again, that sort of thing. So what happened, the states of Illinois, Virginia, and Nevada ended up suing, along with another case in Massachusetts. Equal Means Equal and another women's organization sued the archivist to compel publication. And again, they couldn't meet the burden. And the Trump administration was fighting back. Well, based on the Biden administration's campaign statements, everyone had presumed that the Biden administration would have published the Equal Rights Amendment on day 1. And recently, I was writing an article and I went back and looked, and Vice President Harris actually said she made the Equal Rights Amendment a priority on day 1. In 2019, she said it would be a priority for me and I would make sure we got it ratified, meaning get the last state within her first 100 days. This was when she was a presidential candidate, before she became, backed out and was the vice president. So the Biden-Harris administration was pretty strong on getting this done. When they took over, though, they didn't publish the Equal Rights Amendment. And in fact, they continued the Trump administration's lawsuit against the Equal Rights Amendment in court. That court case since has been resolved to the tune of you can't overcome standing. So we still don't have a ruling. We need the Equal Rights Amendment, though, in the Constitution to address so many issues, including reproductive rights, LGBTQIA rights, equal pay, discrimination bias, pregnancy discrimination, affordable childcare. I mean, I could go on with all of the things the Equal Rights Amendment helps. And, it has a substantial impact on our democracy as well. It's the tool we need to start repairing all of those things. And the most significant reason is, if you look at the Dobbs decision, which rolled back our reproductive rights, overturned Roe, there are certain standards that are applied whenever you have a constitutional challenge to a law. Courts will use different levels of review. And typically, under the 14th Amendment's equal protection clause that Justice Scalia says, doesn't apply to sex-based discrimination, race, religion, national origin, they get this strict scrutiny standard of review. And that's something that the Equal Rights Amendment would have. The 14th Amendment didn't apply to women until 1971. And when they did, they made up a standard of review called intermediate scrutiny. And that is a step below strict scrutiny. The Dobbs decision went even further and took it down to what is called a rational basis standard. If you think about this in terms of likelihood of success, under the Dobbs standard, we only have a 20% chance of winning a sex-based discrimination claim. Pre-Dobbs, with this made-up intermediate scrutiny, for whatever reason, women still were not afforded full equal protection under the law. It increases to a 47% chance. So we were in this mixed like area. It's a likelihood of success, what the scrutiny is. It's how, whether or not the government, if you have strict scrutiny, it's whether or not the government has a compelling interest, narrowly tailored to fit the law it's trying to, and the issue it's trying to address. In the case of strict scrutiny, there's a 73% chance of winning a sex-based discrimination claim. So to step back, with the ERA, we have a 73% chance of winning. With Dobbs, we're down to 20. We need the Equal Rights Amendment to even establish a discrimination claim, let alone have reproductive rights. And with respect to reproductive rights, state equal rights amendments have been used to defeat abortion restrictions. It's happened in New Mexico, Connecticut, even the Utah abortion ban that was supposed to take effect the minute the Dobbs decision was rendered. It was a springing ban. The court has put it on hold because they have an equal rights provision in their state constitution. To drive that point home, in February of this year, there was a hearing on the Equal Rights Amendment in the Senate Judiciary Committee. And the opponents of the Equal Rights Amendment made clear exactly why the Trump administration blocked the Equal Rights Amendment when it did in 2020. Because it protects reproductive rights. You heard the fear mongering going on about how we were going to have abortions on demand at 40 weeks. And it protected LGBTQIA plus rights. And you heard testimony from witnesses that it would mean that, our bathrooms would be unsafe. Women wouldn't be allowed to participate. All the stuff you're hearing, the negativity you're hearing on a regular basis related to transgender rights and reproductive rights. And that is why they oppose the Equal Rights Amendment, because the Equal Rights Amendment saves that. But one interesting point to note is the Trump administration actually blocked the Equal Rights Amendment without authority, mind you. There's no role for the president in this process, just the librarian, who is an executive branch employee, to collect the certifications and print a revised constitution once it meets the threshold. However, the Trump administration already controlled a majority of the court. It was already a conservative majority at the time it blocked the Equal Rights Amendment. They knew that this originalist, I think you may have heard the terms, that this court just looks to the words that are actually in the Constitution. There's no word deadline in the Constitution. There's no word rescission in the Constitution. In fact, there were rescissions attempted in connection with the 14th Amendment. Ohio and New Jersey attempted to rescind their ratifications, as well as with the 19th Amendment, Tennessee attempted to rescind its ratifications. We'd be in kind of shaky ground if this Supreme Court all of a sudden started looking to respect rescissions. So you can kind of see the plan and what was going on and why the Equal Rights Amendment has been blocked. It is so important right now to get it into the Constitution. I can say, as a member of the ERA, National ERA Publication Task Force, we began advocating at the end of 2021, before the Dobbs decision was leaked, urging them to publish the Equal Rights Amendment to avoid the Dobbs decision. They didn't. We went to them again after it was leaked. They still didn't. we're now in a situation where we've seen what's happened. Dobbs is about more than reproductive rights. Dobbs is about really erasing the rights of women. I mean, we've seen the Rahimi case where we're putting guns back in the hands of known domestic abusers. We're seeing attacks on no-fault divorces that were so essential to women for so many years in domestic violence situations. We're seeing what these draconian reproductive abortion bans essentially is what they are, but they're impacting reproductive health care. Look no further than Kate Cox last week. We're at a point where we have to recognize the fact that we're on the verge of losing all equal protection. And that is simply explained by the fact that there's currently a case before SCOTUS that they may hear this term where the Kentucky and Tennessee gender affirming care bans are being challenged by the children and their families as sex-based discrimination. The lower court applied the Dobbs rational basis standard of review, giving us like no chance of winning, 20%. And they upheld the bans because you're not going to win if you're under the Dobbs standard for sex-based discrimination. You're just not. They can make up reasons and it's, oh, well, that's kind of reasonable. It's colorable. It's a colorable claim is what I've heard it referred to as. If this case on the gender affirming care bans in Tennessee and Kentucky gets before the US Supreme Court without the Equal Rights Amendment in the Constitution, we run the risk that the Supreme Court issues a ruling similar to Dobbs, stating that equal protection claims based on sex only get this 20% likelihood of success standard of review. And that means we're without a remedy for sex-based discrimination. So there's a lot at stake, and we need to do it urgently. And another point I want to make is, other than the ERA being, the way to solve these issues, to get us back up to the 73% chance of success, is that you hear sometimes politicians talk about codifying Roe. That is not possible until the Equal Rights Amendment is in the Constitution. Congress can only act with authority granted to it by the Constitution. And currently, there's no authority in there after Dobbs because the court ruled there is no right to privacy. So there's nothing it can fall under for Congress to have the authority to regulate it. And the Congressional Research Service has actually said so much. Maybe you can make a Commerce Clause argument, but they know that this court has already indicated it would strike it down. So first step is putting the Equal Rights Amendment in the Constitution and then having Congress enact laws with the authority to do so. Otherwise, we're relegated to relying on our states to come through. And we know that how many states are not going to be able to enact these provisions. I mean, as Julie said, I'm from North Carolina. We're not going to be able to enact protective legislation for decades. So what we have been doing is we have been building a broad coalition of people and trying to educate and get the word out on these issues because it is so vital and it is so urgent. This is 100% a political issue at this point in time. It's not a legal issue. The scholars have, made clear where they stand on this. But the question is there the political will for the issue? There's two resolutions currently in Congress that call for the archivist to publish the Equal Rights Amendment. The House version was proposed by Representative Cori Bush from Missouri, and the Senate version was proposed by Senator Gillibrand from New York. We're building a broad coalition of support within the Senate and the House for those resolutions. But those resolutions, one, we all know aren't going to pass, right, in this climate. But that's not what they're designed to do. They are not something that is binding on everyone. They're sending a message with these resolutions. So there are currently 21 co-sponsors. It was just introduced at the end of the summer. 21 on the Senate side and 67, I believe, on the House side. So there's already 80 people right away on board, including Senator Durbin, who's like a very high-ranking senator from Illinois and a moderate. So because we got Senator Durbin on board, we expect more to come. But the idea is the more representatives, the more senators we have, the more pressure we're putting on the White House to actually get this into the Constitution. Now, will there be challenges? Of course. The far right, that is the Christian nationalists, they're not going away. But the Trump administration wouldn't have blocked the Equal Rights Amendment when it controlled the court if we didn't have a much better shot. And as of right now, it's just sitting in this legal limbo and we can't get it out until it's published. As a result, 6 states have recently affirmed, state legislatures have recently affirmed the validity of the Equal Rights Amendment. California, Colorado, Minnesota, Michigan, Illinois, and Hawaii. And Illinois, Hawaii, and Michigan have called for the president to put it in the Constitution ASAP. And California is literally repairing its laws as if the ERA were already the 28th Amendment. And they track it on a website. You can literally go on their website and see that the ERA, how they need to change it to comply with the ERA. In the case Illinois versus Ferriero, there were 20 blue states that stated the ERA has met all requirements of Article 5 to be the 28th Amendment. It is the 28th Amendment and must be published. So on one side, you have the Trump and Biden administration, Alabama, Louisiana, Tennessee. No, I don't think it was Tennessee, South Dakota. On the other side, you have 20 blue states, hundreds of women's rights organizations, constitutional scholars saying that this is done. Most recently, the North Carolina Democratic Party passed a resolution calling for President Biden to immediately publish the Equal Rights Amendment, and Democrats Abroad, which is the state party equivalent for all of our expats, did so as well just last month. You may not know this, but the United States is the only developed nation without gender equality in its constitution. And just last month, the United Nations called upon the Biden administration. The United Nations Human Rights Committee called upon the Biden administration to put the Equal Rights Amendment in its constitution. So it's coming from all angles. We just need more, everyday people understanding these issues. So again, we go out, we educate, we try and spread the word. Most recently, on December 5th, we submitted a letter to the president on behalf of 84 organizations. And it was a diverse collection of organizations. It was not just all of the gender justice organizations. It was democracy-focused organizations. It was the American Constitution Society. It was military women organizations. It was domestic violence organizations. It was political organizations. It was the National Women's Political Caucus. I mean, most importantly, it was medical associations, Physicians for Reproductive Rights, American Medical Women's Association, Doctors for America. these medical professionals are on the front line. And this isn't the first time the American Medical Women's Association has written to the president to call for publication. They're on the front lines of the reproductive health issues, and we need help. And the Equal Rights Amendment is the first step to getting that done. Thank you, Julie.
All right, I had to unmute myself, and I'm gonna try to bring myself up here. Give me 1 second. Okay. Thank you so much. That was so much information that you just
I
threw.
know.
So
I hope everyone's still awake. It's kind of dense. And that's one of the challenges.
no.
Thank you, Rosalie.
Rosalie, thank you, Rosalie. She'll cheerlead us on. So I think I want to clarify just so people understand, because you guys, I mean, I have a law degree, and I talked to Nicole about this, and it took me a good couple of times going, wait, explain that to me again. So I want to make sure that I've got that down. So we keep hearing that, you know, if you get the right people elected, we can pass a national law that will, you know, protect abortion rights in the country. So now, obviously, they can pass whatever law they want, but it would get challenged. And your concern, or what you're saying would happen, was that would likely be struck down because we don't have anything in the Constitution right now that actually protects against gender discrimination. Am I repeating that accurately?
Yes. Well, in theory, we have the 14th Amendment, but they have eviscerated it to the point where it's only this 20%. We're like about to get a hard decision once SCOTUS hears this last gender affirming care ban case. But the key is that Congress can enact laws if it has a power expressly set forth in the Constitution. Like interstate commerce, it can make laws that impact interstate commerce. Abortion doesn't fit into any of those hats that Congress has the right to do stuff about, unless you have the Equal Rights Amendment in the Constitution. It can't jam itself in one of those buckets. So say they enact the Women's Health Protection Act. First, it'll be immediately enjoined. And that means that it'll never take effect. The court will say, nope, hold on until we decide on the merits if this is good. They're going to make it all the way through to the merits, and they're going to determine that Congress has no basis, unless, of course, the Equal Rights Amendment was in the Constitution. Because the Equal Rights Amendment is those 24 words, and there's two other sections that we don't really talk about because they're kind of self-evident. The one is the Equal Rights Amendment took effect 2 years after it was enacted, after it was finally ratified. So it's been in effect since January 27th, 2022. The other provision is it expressly grants Congress the right to enact laws to further the Equal Rights Amendment. So that would give them the authority to enact abortion protection, gender affirming care protection, anything that an Equal Pay Act that you can't drive a truck through, because you know the current one you can drive a truck through it.
So basically, by putting the Equal Rights Amendment in the Constitution, it is giving Congress the authority to pass all kinds of laws that protect on the basis of gender and equity, which right now that's missing from our Constitution. So Congress can try,
Right.
but it'll get challenged, and there's a very good chance that it would not be upheld because the standard you're talking about, this like very small, like low standard they have to meet to say the government has a good reason.
Right.
Not,
exactly. That's
like,
that's literally it.
Not strict scrutiny, which is, man, you better have a damn good reason for doing this. You know, we're talking a low level so they can kind of make up anything that the government has an interest
That's
in.
right.
Why do you think that the Equal Rights Amendment just isn't? I mean, this sounds incredibly important, and it's on the front lines of everything we're dealing with in this country right now. So why do you think this is getting no attention? Like, why is the media not talking about it? Why do we not ever really hear about it?
It's such a great question, Julie. It's such a great question. Well, there's a media block. I can tell you that. They don't want to talk about it. One, I think there's a small component of journalists who, this is kind of a complicated issue. So they have short periods of time. They don't have law degrees. I mean, it's just, so it's not, and it's also not very sexy. People have started talking about it more once Roe fell than they did before. Like we were advocating beforehand. And we're like, excuse me, the train's coming off the tracks. Can you please put this in the Equal Rights Amendment? The other part is there's too much money at stake. The corporations have a vested interest in this not happening. The gender pay gap alone costs women and their families $1.6 trillion a year. And if you factor in our unpaid work, I think you might have heard recently, there's a lot of talk about the value of all the unpaid work we do as women. That's another $600 billion a year. I mean, this is like some serious money. And it's threatening. It's threatening too.
So just to be clear, why do you think the Biden administration hasn't given a reason for not publishing it?
Yeah, that is the $1 million question. I mean, I could surmise a few different reasons of why it wasn't published originally. But we're at a point now where if they publish the Equal Rights Amendment, I think it would be a win for the current administration. I think it would be a wise move given where things stand right now. Why do I think they're not? Because they're using reproductive rights and abortion as the key to, they believe is the key to getting women to come out and vote. And that's just simply using fear. The other side is worse. Well, in this particular instance, we have two administrations that did exactly the same thing, made the exact same arguments. The difference is that the Biden administration makes statements. It just made a statement on the 100th anniversary of its introduction in Congress. President Biden said, it's about time that the Equal Rights Amendment is the law of the land. Well, that's kind of gaslighting, because he knows that the Equal Rights Amendment is the law of the land. But even if he disagreed, he should come out and say he disagrees. He should say there's an issue with it.
What's the
And I think
reason, or what's the motivation, do you think, for Senator Gillibrand and Cori Bush and the other members of Congress who are now behind this resolution? Because obviously they're standing up and using their voice to say this
Right.
needs to be implemented. So what's the motivation? Is it Roe?
Courage.
Roe or okay.
It's courage, because what people will tell you behind closed doors are very different with what they'll say in public. And the courage that these representatives and senators on these resolutions, some of which Senator Blumenthal, Senator Klobuchar, and Senator Cortez Masto, Cortez Masto is from Nevada, Blumenthal is from Connecticut, and Klobuchar is from Minnesota. They wrote a letter to the Biden administration in January of 22, urging them to publish the Equal Rights Amendment. They've been on record for a while. But the thing is, as part of our efforts, part of our work, we've gone to the governors. The governors can't get an answer out of the Biden administration about why they're not publishing. But yet there are statements to the contrary. For a while, the Biden administration called on Congress to take action. But yet in court, when his administration was fighting against the Equal Rights Amendment, he said Congress has no authority to act at this time. Once Congress passes it, it goes out to the states, and Congress has no authority on the back end. So I wish I had the answer.
I was going to say, I have a couple more questions, and Janice, if you get a chance, if you could look in the chat for me, I'm kind of skimming through to see if there's any questions. If you guys do have any questions that you would like answered, please feel to drop those in the chat and we'll pull those out in a second. Obviously this is rather complicated because there's a lot of legalese and everything involved in this. So what are some good resources for people if they want to learn more about this or really do kind of a little deeper dive, whether it's Is there a good book? I mean, obviously you can talk about what's on your website, but any other good
Yes.
places for people to go to get resources on this?
I'll send you to my website, which is shatteringglass.org. There are numerous like blogs, and you'll find our testimony before the Senate Judiciary Committee on there. You'll also find the letter those organizations wrote this week to the president. I will pop that in the chat here now, because that, if you look at the letter with the footnotes in it, you can read more from there, and the Senate testimony from there, and it kind of tells the whole story. That's what I would suggest. I know there are some ERA activists on it, but on here right now, if they know of any good book, I can't think of one good book to go read. So, but yeah, I would definitely point them to the website, shatteringglass.org, and there's a lot of information on there. And let me get that letter and pop it in the chat.
And then Janice, did you see any questions in the chat that you want to uplift?
Yeah. So, let's see, now they're fine. Is there anything that we can do as individuals?
Yes, there is a lot you can do. First and foremost, we need to get the word out. So if we could share this information, talk to like-minded friends, people who care about reproductive rights, people who have a daughter, people who have a son who's going to marry a woman. Like, I mean, just this impacts everybody. This is men, women, girls, boys. The Equal Rights Amendment will help everyone. It helps businesses, it helps communities, it helps our democracy. We've heard our elected officials, Secretary of State Blinken and the president and the vice president say, you know, the strength of the democracy is dependent upon how we treat our women. And the strength of democracy, it's usually talking about other people's democracies. That applies here too. And we are on some shaky ground. The Equal Rights Amendment would have a chilling effect on the Christian nationalists that are attacking all of these social issues that are causing us so much heartache. In the chat, I am going to put here, I'm going to put a link to the letter, as well as on our website, there is a take action page, and that is updated fairly frequently. But another way you could do this is about following us on social media. Share the posts. We're normally trying to engage folks in current events and how the current events relate and how the Equal Rights Amendment would help. The Kate Cox story. People aren't talking about reproductive rights in the Equal Rights Amendment. And I think a part of it is a lot of people don't want to solve the reproductive rights issue. And again, a lot of people don't want the Equal Rights Amendment because of the amount of money that is at stake. So.
Yeah, I can definitely understand that there's a lot of money involved in this issue to maintain the status quo. Janice,
Julie, there's several questions here. So someone asks, is there a media kit or tools that we can use to push out to use for our social media posts? Is that on your site, Nicole?
It's not a social media toolkit, but no, that is a really good idea about having a toolkit available for folks, and we will get that together. But it's more following us and sharing for the time being. But I really do like the idea of a toolkit. These are the posts you can use. This is what you would say with respect to reproductive rights or democracy, or, you know, the improving the lives, the blanket statements, improving the lives of women. And it's like, well, we've got something over here we'd like help with, that kind of thing. But yes, thank you. We will get on that and get back to Janice and Julie with that.
Okay. So going back to some questions earlier, so why does scrutiny matter? I know that was a little bit of discussion in the chat, but why does scrutiny matter?
So the scrutiny is, I mean, Julie summed it up nicely. It's kind of like, if you have this, it's the way the court looks at the law. It's like scrutiny is now, are we going to hold them to a high standard or, a medium standard, or are we going to leave them with whatever they want to do?
Mhm.
Dobbs is, well, they kind of have a reason. Intermediate scrutiny is, well, I can see that, they have a pretty good reason. And then the strict scrutiny is, you better have a damn good reason. And it better be tightly written to just address that reason. So that's how it goes from 20 to 40, 47 to 73.
So it helps determine kind of the likelihood of being successful,
Yes,
those levels. Mhm.
that's
Okay.
exactly right.
Okay.
Yeah. I was gonna say the court, I'm just speaking as a layperson, like language with this, but like the court has that, they set a standard. So for if you're gonna challenge the government and they pass a law, and the court has standards that they review that law under. And so some laws have to be reviewed under strict scrutiny, which means the government better have crossed every I, every T, they better have a really good reason for doing this, and they have to like have the highest levels to keep that law on the books. But what she's saying is that for Roe, they set the standard pretty low. So the government can just come up with kind of a BS excuse as to why they had to pass that law. And if they can come up with a BS excuse, it'll stay on the books. So there's a different level of like what the court looks at and what level the government has to be able to say why they passed this law. So I don't know if that clarifies it anymore, but it's a hard concept. And we did a lot of law school around that. So it's a hard concept.
Right?
Okay.
I'm
All
sorry,
right.
next question, Janice.
Like a year, Julie, right? It was like
Okay. So what are the political risks to the Biden administration of publishing the ERA?
not. I mean, in theory, I'm assuming he'd say, if I were the president, the political risk could be that, the Supreme Court strikes it down. That if it strikes it down, it strikes it down. But then you're going to have, 187 million women, girls, and LGBTQIA plus people fully aware of what's going on. As of right now, we've put it in a drawer and nobody can see it and nobody knows what's going on. So taking a stand for more than half the country, I don't see the political risks. I think it's all game. Particularly given, again, I'm going to go back to it, the Trump administration controlled the court. They had a conservative majority at the time he blocked it. He felt compelled to block it. I think we're in pretty good shape if you look at who these people are. And some people take the position that the president has a constitutional duty to publish the Equal Rights Amendment under other provisions of the Constitution. He has a duty to uphold the Constitution for sure.
Okay.
That's what we tell the senators too.
So someone asked, VP Harris is about to go on a reproductive rights tour. And the question is, does this group or any of us, this group or your group does your network have plans to bring this to her face to face?
Face to face is probably going to be the way we have to do it. We've attempted to do it through her chief of staff and her counsel. So on her reproductive rights tour, we're going to have to hit the stops for sure. It's the only way.
Okay. Is there a particular organization or coalition to follow for advocacy updates?
Yeah, we send out regular updates at shatteringglass.org.
Okay.
And that includes, updates from the publication task force as well.
Okay.
Okay, by the way, all of your little graphics in the chat are amazing. So I just wanted to shout those out. All I want for Christmas is the ERA. Some other ones, it's good.
Someone asked, someone reviewed the list of 84 organizations within the Shattering Glass Coalition and wanted to know, how can new groups contact to join, I guess, on that?
Absolutely. So I put in the chat a link that includes the letter And if you look at the beginning of it as a blog post, there's a way to sign on either as an organization or as an individual. You can do both. We're keeping it open. We have more organizations joining. I think we had 3 join today. It's continuing to grow, and we're just going to keep updating. The legislatures today asked, we were on the phone with Senator Duckworth's office from Illinois. She said, please let us know who's signing on from Illinois and what military organizations, because she's dedicated to military people. Obviously as a veteran.
Okay, and let's see, the last one that I've collected as I've been monitoring.
Here's the link. Oh, sorry.
What can we do now that would have any effect? What can we do right now?
That would have any effect?
Mhm.
Sign on to this letter I just put in the chat. Text the president. Call your representatives, call your senators, and tell them to sign on to these resolutions that are referenced in the chat. The one from Representative Bush and Senator Gillibrand. And you could find additional action items at Shattering Glass Tech Take Action page. Like, we're regularly updating these, and it's constantly moving based on the conversations that we're having daily with these folks trying to get this over the finish line. But honestly, the most impact you could have right now is to tell more people that there's a way out of this, and to explain to them and share this information with them. Because the more, as Julie pointed out, with the media not covering this, it has made our job so much harder. It's spread the word, please.
I wonder what like letters to the editors, op-eds.
Yes. Well, letters to the editors have been fantastic. There's a woman on here, Jean Sweeney, that actually did a great one recently. But responding to articles and writing, in response to articles that are published is a great way to address that, Janice. Because it is so technically legal that people say, oh, well, we need to pass the ERA, or, we need to ratify the ERA. People could be doing that innocently, right? But these articles are out there that say, we need to ratify the ERA. No, it's ratified. It just needs to be in the Constitution. It's ratified. It needs to be in the Constitution. And I do believe people use these terms innocently, but there are other people who glam onto that. And when there was a hearing on the Equal Rights Amendment in February, we got a lot of negative press, like the ERA is, the vote failed and the ERA, is dead. And it was some bad press. If you have questions, please reach out to me anytime. Anyone. I will talk about this with anyone. I will provide you materials, anything you need. We just need to get the word out, and we're so grateful for you all being here and listening and spreading the word.
All right. Well, everybody have a great evening, and thank you for taking the time. And Nicole, we appreciate the information. So thank you for being here.
Thank
Good night.
you.
Bye.